Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 4 of our new program entitled Update on the QME Regulations. And I should remind you that what we're discussing in this series are new proposed changes to the QME regulations. These are changes that are not yet passed and are not yet written into law. They're simply at this point in time being proposed. That means that they're going through the public comment period and they're going through the sequence of events that are required for any changes to the law to be finally passed and enacted and written into active law. But even though these proposed changes are not yet official, I fully expect every single one of the new proposed changes, with perhaps only slight modification to the language of the regulation, I expect all of these to be passed and to become enacted, because all of the new proposed changes that we're talking about in this series represent positive, beneficial improvements to the system as we know it. So we can discuss these new proposed changes as if they are actually going to be the new way of the future, because every single one of these, there's nothing wrong with any one of the new proposed changes. As far as I can tell, based on my reading of these new proposed changes, they all represent significant improvements to the system, and I'm sharing some of those improvements with you in this discussion. Now, in our first session, we had sort of an overview of some of the select changes that are going to impact the day-to-day operations of you as a qualified medical evaluator. And some of those changes are administrative. Some of those changes affect your face-to-face evaluation. Some of those changes relate to the production of your report and the submission of your reports on the parties. And we had a brief overview of some of what I consider to be the more important changes to the QME regulations. In session number 2, we started dissecting with a fine-tooth comb some of those selected changes, and we talked about what CCR 31.3 has to say with regarding scheduling appointments with you for a prospective examinee for a qualified medical evaluation. And just a couple of comments about this discussion. I've received some feedback from some qualified medical evaluators who had some questions about the recommendations that I provided in that session. And in that session, I advised and I recommended that you be a bit stern on the scheduling of your appointments and schedule only those appointments for which you have complete information. Complete information includes a copy of the panel, and includes a copy of the QME Form 106 that the parties used in requesting a QME panel. It includes complete demographic information with emphasis on the word complete. Specifically complete in the sense that the demographic information that you've received allows you to fully do what you need to do in completing your responsibilities, such as filling out the QME appointment notification form. There are certain pieces of data that are required to be entered on the QME notification form. Many times, the demographic information that the parties send to us doesn't contain adequate information that allows us to even complete the QME appointment notification form. So that's a problem. Finally, complete information includes copies of the strike letters that unequivocally leave you as the last man standing with no dispute from either of the parties that the evaluation is to move forward with you as the qualified medical evaluator. It's only when you have complete information can you be reasonably assured, and I say reasonably assured because you can never be totally assured, but it's only when you have complete information can you be reasonably assured that the appointment is a bona fide, compensable appointment for which you're going to be reimbursed, and you're not just going to be spinning your wheels setting up appointments that later become rescheduled, canceled for a plethora of reasons. And Qualified medical evaluators have some concern about being too stern in requesting or demanding all of this information up front. But my position on this is that even the most complete appointments, the appointments for which you receive complete information, only approximately 60 to 70% across the board, across the industry, in all specialties, only about 60 to 70% of appointments keep. Well, you want to be in that 60 to 70% group, and the way that you assure that you get in that group is by beginning properly with all information. So don't be ashamed, don't be afraid, don't be abashed by demanding that the parties who are requesting an appointment with you provide you with the necessary information that you need to launch this appointment. Thereafter, you can be willing to do some of the work on your own to get whatever information you need, but at least up front in the scheduling phase of the appointment, demand from the parties that they provide to you what you need to schedule the appointment. So that was in session 2. In session 3, we began a fascinating discussion about the DWC's new approach to combating bias, not only in the workers' compensation system at large, but specifically as relates to us in combating bias in the medical legal evaluation. And I shared with you in this discussion where in the life cycle of a qualified medical evaluator the Division of Workers' Compensation is going to target doctors to ensure that doctors' opinions and conclusions are free from any forms of bias. And just to reiterate the message of our last discussion, the Division of Workers' Compensation has a plan to target new prospective QMEs and educate new prospective QMEs. They have a plan to educate existing QMEs, and they have a plan to discipline QMEs who are found to be engaging or harboring biases in their opinions and conclusions. So all along the life cycle of a qualified medical evaluator's career, the Division of Workers' Compensation has a plan to stamp out or at least minimize bias and discrimination in the medical legal evaluation. Now, in today's discussion, we're going to continue with our discussion about bias in the medical legal evaluation. This is going to be part 2. And in today's session, I'm going to share with you how it is that the Division of Workers' Compensation has this new interest, this new focus, this new intent to address bias. And I'm going to share with you where that came from and what was the genesis of this new impetus to push qualified medical evaluators to more sincerely provide opinions and conclusions that are not based and not founded on any type of gender discrimination, race discrimination, religious discrimination, or discrimination in any of its many forms. So this is going to be a fascinating discussion for you, and it's going to form the basis for an upcoming series that I'm going to begin in the very near future, which is going to be a 6-hour discussion on anti-bias in the California workers' compensation. So with that as our introduction, let's begin today's discussion. We're in the update on the new QME regulations. And today we're specifically talking about bias and stamping out bias in the medical legal evaluation. Okay, so let's begin. So the first step in the Division of Workers' Compensation's plan to eliminate bias in the medical legal evaluation has to do with implementing new education for qualified medical evaluators. And that educational program is going to span the entire career of the qualified medical evaluator's lifespan as an evaluator. And specifically, the language that's proposed in the new QME regulations states that the instruction, the purpose of the instruction, is to increase awareness and understanding of differences in human experience, as well as an awareness of implicit or unconscious bias, stereotyping, and discrimination. And we're going to define these terms here. And the ways in which unconscious bias can unintentionally impact perceptions and, most importantly, decision-making, medical decision-making that we, as qualified medical evaluators, offer in our reports, including in medical evaluations and reporting, and therefore can lead to disparities in healthcare strategies. So in other words, the Division of Workers' Compensation has discovered that our inherent stereotypes and our inherent implicit biases affect our medical decision making and affect different groups of people, different populations of examinees differently. That our decision making based on biases and stereotypes lead to disparities in healthcare strategies. So whereas we may have two different examinees with the exact same case, the exact same scenario, the exact same facts of the case, the exact same or similar examination outcomes, can lead to differential opinions and conclusions for these two different examinees based upon the inherent and implicit biases deep within the mind and the recesses of the qualified medical evaluator's experiences. And these disparities is the target of the Division of Workers' Compensation. The Division of Workers' Compensation wants equal and fair treatment for all examinees, regardless of the typical targets of discrimination, such as race, such as sex, such as gender, such as religious affiliation, etc. The Division of Workers' Compensation wants our opinions and conclusions that we offer in our report to be free of disparities that are based upon our unconscious biases and our stereotypes. Okay? So let's define some of these terms so that we can have a better understanding of exactly where the Division of Workers' Compensation is going with this. Okay, so the Division of Workers' Compensation is using such terms as unconscious bias, implicit bias, stereotyping, and discrimination. So let's define some of these terms so that we can have a better understanding of just what the Division of Workers' Compensation is talking about. And the definitions that I want to share with you today come from no less credible a source as Wikipedia. And Wikipedia tells us that implicit bias, also known as implicit stereotype, is the pre-reflective, before you've had an opportunity to even reflect on the situation. It's the pre-reflective attribution of particular qualities by an individual such as you, such as me, such as us, as qualified medical evaluators, to a member of some social outgroup. So the social outgroup, them, the other people. In the case of us as qualified medical evaluators, this could be us as qualified medical evaluators and them as injured workers. And I can't tell you how many times I'm guilty of this myself. I'll be sitting at my desk, I'll be reviewing some medical records in preparation for an upcoming face-to-face evaluation, and I'll start to get what I consider to be a mental image picture and some perceptions of my examinee. I'll start to develop an opinion about the examinee's situation. I'll start to develop a picture in my mind of what the examinee looks like based upon descriptions in the medical records. And I'll start to find myself formulating the outcome, the opinions and conclusions of my report, even before meeting the examinee face to face. And I can't tell you how many times the stereotype that I develop, the pre-reflective qualities that I attribute to my examinee, how many times they turn out to be inaccurate. I can tell you that I myself am guilty of this all the time. And it happens all the time. And so it's because of implicit biases and implicit stereotypes that we unconsciously start to attribute particular qualities to an individual that may not may not actually be accurate. And those inaccuracies can be what it is that contributes to faulty opinions and conclusions. In our reports, and the Division of Workers' Compensation is taking direct aim at this particular phenomenon. Implicit stereotypes. These are thought to be shaped by experience and based on learned associations between particular qualities and social categories, such as, this should say, not say including, it should say such as race and or gender. And the Division of Workers' Compensation has added other categories to this list as well. Categories such as sexual orientation, categories such as national origin, and categories such as religious affiliation. And I'm going to share with you, we're going to go through an implicit stereotype exercise here in just a moment, and we'll see just how some of these stereotypes play out in our day-to-day learned associations. Okay, finally, according to Wikipedia, individuals' perceptions and behaviors. Now, think about this in terms of you as a qualified medical evaluator. Your perceptions and behaviors can be influenced by the implicit stereotypes that you hold. Even if they are sometimes or even all the times, even if you are sometimes or even all the times unaware that you hold such stereotypes. Implicit bias is an aspect of implicit social cognition, the phenomenon that perceptions, attitudes, and stereotypes can operate even prior to conscious intention or endorsement. So these stereotypes and implicit biases that we hold based upon our experience, based upon our learned associations, are operative at all times. And they shape our perceptions of our examinees and can contribute to opinions and conclusions that are not accurate, And the Division of Workers' Compensation has assembled a library of cases that represent inaccurate opinions and conclusions that are based on the Qualified Medical Evaluator stereotypes. And this is what the whole target of the new anti-bias movement is intended to help stamp out. Okay? So let's go through a little exercise about implicit stereotypes. Okay, so let's take a look at this phenomenon a little bit more closely and see how this may impact us as qualified medical evaluators. Now, if according to Wikipedia, stereotypes and implicit biases are learned associations that are shaped by our experience about particular qualities and certain social categories. If that's true, let's take a look at some of those. Let me share with you a list of certain social categories, and I want you to think for a moment about what types of qualities, what particular qualities do you stereotypically attribute to that particular social category. So for example, if I say the word to you jocks, you've all heard that term, what type of learned associations do you have with jocks? What particular qualities do you associate with what are described as a social category of jocks? Okay, so what do you think of? You probably typically think of young males, perhaps high school, perhaps college male athletes, very interested in sports and sports culture, but perhaps not very interested in intellectual culture. The stereotypical jock is not very much interested in carrying a conversation, unless, of course, that conversation revolves around sports and particularly revolves around his own performance and his own successes in sports. Okay, and we have this stereotypical image of what we refer to socially as jocks. Okay, what if I say the term nurse? When we refer to nurse, what do we stereotypically, what particular qualities do you stereotypically associate with a nurse, you typically associate, first of all, that the nurse is a female gender, correct? Typically. Now, we all know that there are male nurses, but stereotypically, nurses are female. Nurses are very caring, they're very gentle, they're very kind, they're very loving, they're very soft, they're very nurturing, and we associate these qualities with this particular social group, stereotypically, that we refer to as nurses. Okay, now of course there are nurses that do not fit the stereotype, but typically, stereotypically, we think of them in these ways: loving, caring, kind, and particularly female. Now, on the opposite end of the spectrum, when I say the term engineer, you typically, stereotypically, think of a male figure who's very precise, perhaps wears glasses, perhaps is very conservatively groomed, very conservatively dressed, very fastidious, meticulous, detail-oriented type person. And we have these stereotypical qualities that we associate with this particular social or occupational group. Okay? Now, what about an elementary school teacher? And we won't belabor this point forever, but when we talk about elementary school teachers, typically or stereotypically we think of them as female, again a lot like nurses, very nurturing, very caring, very loving. I have in my chiropractic practice an elementary school teacher, and she typically wears Panda Bear or Pooh Bear and Winnie the Pooh type of t-shirts that she wears, and we have this stereotypical image of this very soft, very caring, typically female type of stereotype. Okay? Now, let's talk about an adjective. Let's use an adjective and talk about a lazy person. When we talk about a lazy person, what type of a mental image picture conjures up in your mind when you think of the term lazy? Would you think of perhaps an overweight male lying on the couch, maybe watching a sports program on a Saturday or Sunday afternoon, perhaps wearing a too small t-shirt with a big pendulous abdomen hanging out the bottom of the t-shirt? There might be some beers on the countertop on the coffee table in front of the person. There might be an empty pizza box. Typically, this person would be lying on the couch with no shoes on, with no socks on, would be wearing a pair of shorts, maybe yesterday's shorts, and the person is probably unshaven, and we have all these stereotypic attributes of qualities that we pre-reflectively apply to this social group. Now, are there lazy people who are fit? Are there lazy people who are well kept? Of course there are. There are people that do not fit the stereotypes, and the Division of Workers' Compensation is asking us to eliminate stereotyping from our opinions and conclusions. So the targets that the Division of Workers' Compensation has identified as targets wherein qualified medical evaluators harbor biases that adversely impact injured workers include the injured worker's race, and I have a case to share with you coming up that illustrates this beautifully, where racial discrimination impacted the qualified medical evaluators' opinions and conclusions, which adversely affected the injured worker's opportunity to pursue workers' compensation benefits. Sex and gender issues such as pregnancy, such as sexual orientation, that may also fall under the category of sexual preference, transgender status, and this impacts a qualified medical evaluator's opinions and conclusions, which I'm going to share with you in just a minute, regarding breast cancer and carpal tunnel syndrome, just to name a couple of conditions that affect women that are typically evaluated by male evaluators, wherein male evaluators harboring stereotypes and biases related to sex and gender discriminates against women in the receipt of permanent disability benefits and in the Qualified Medical Evaluator's apportionment determination, and I'll share some more of that with you in just a minute. Other targets include national origin, include religion, and include sexual preference, including lesbian, gay, bisexual, transgender, and queer as a sexual preference. Division of Workers' Compensation wants to make sure that qualified medical evaluators do not harbor any stereotypes or biases or attribute any particular qualities to these people in the provision of accurate opinions and conclusions. Now, sexual preference is very interesting, and in terms of discriminatory conduct, this seems to be a great target in society and in qualified medical evaluators in general. So let me share something interesting with you from the popular culture, wherein discrimination against these particular groups is making, or I should say, anti-discrimination efforts targeted against these groups is making great progress. So let me ask you, do you think it's possible to be free of bias, to be free of stereotypes, to be free of preconceived, pre-reflective attributions relating to race? Is it possible to be free of bias regarding sex or gender? Is it possible to be free of bias regarding national origin, regarding religion, regarding sexual preference? Well, let me share with you a story from recent pop culture that shows at least one organization making great progress in this area. And what I want to share with you has to deal with a story that I came across in Time magazine regarding the 2021 Miss Nevada, Catalunya Enriquez, who is scheduled to compete now in the Miss USA competition. And here is a picture of Miss Nevada, Catalunya Enriquez. And Catalunya Enriquez is making history because she is the first transgender person to ever compete in these stereotypically all-female competitions. And she's actually the first transgender competitor, and she's the first winner. She's the winner of the 2021 Miss Nevada competition. And she's now going to go on to the Miss USA competition. Now, stereotypically, when you think of these Miss America, Miss USA, these local regional Miss competitors, what do you stereotypically think of? And whatever that is, we're not going to list out those attributes that you may have based on your learned associations over the years with watching these competitions. But this is a woman here, Catalunya Enriquez, that's breaking all of those stereotypes. In fact, you don't even have to be genetically female now to compete in these competitions. So these organizations have themselves taken a look at bias and discrimination, and they're opening up their arms and opening up their doors to more competitors to compete free of discrimination in these competitions. And that's the purpose of the Division of Workers' Compensation's new attempt to stamp out bias in the qualified medical evaluation, and that is to eliminate stereotypes that we harbor that have been fostered and festered within us over the years, so that we can render opinions and conclusions that are accurate and that are free of these stereotypes. So let me share with you now what is the genesis or the origin of the Division of Workers' Compensation's new focus on addressing bias in the medical legal evaluation. So this whole venture and this whole plan to address and stamp out bias in the medical legal evaluation dates back to 2016, when some women filed a lawsuit against not only the Division of Workers' Compensation, but also against the Department of Industrial Relations and the executives in charge of those organizations for what they perceived and what they identified as discrimination in the medical legal evaluation. And I have the lawsuit for you right here. It's a monster. It's 45 pages long. And it's referred to on the internet, if you want to do a Google search on this, it's referred to as the Page versus Parisotto case. And Mr. Parisotto at the time was is still one of the executives of the Division of Workers' Compensation. Now, in this particular case, the attorneys for the plaintiffs made several allegations, and I'll share those with you here. They alleged that California's system of workers' compensation perpetuates the type of overt sex discrimination that is a relic of the past, that the system perpetuates sexual discrimination. And they have many evidences of that in this particular document, including the fact that the preponderance of qualified medical evaluators are male. Large percentage, overwhelming percentage of qualified medical evaluators are male, okay? They further allege that this discrimination deprives women workers of fair compensation similar to the compensation that's offered to male injured workers on the basis of stereotypes about gender and on women's reproductive biology, okay? And they cite many examples of that, and as I referred to earlier, those examples relate mostly but not exclusively to cases that involve industrial breast cancer and the cases that involve industrial carpal tunnel syndrome in injured women workers, okay? And because of this overt sexual discrimination, permanent disability ratings afforded to women are not accurate because they do not acknowledge the harm that's unique to women, the harm that's unique to women. And by failing to acknowledge the harm that's unique to women is discriminatory against women, because women are women. They have no choice in being women, and by not acknowledging the harms that are unique to women, fails to properly results in inadequate benefits provided to women. Okay, and I'll share some examples of that for you. And that finally, apportionment based on gender risk factors is discriminatory. And this is where the Division of Workers' Compensation is going to target us as qualified medical evaluators to confirm and assure that our apportionment approximate percentages, in other words, the percentage of the permanent disability that the injured worker is left with, is not apportioned to gender risk factors, which would be otherwise discriminatory, especially to women. So many qualified medical evaluators, specifically related to cases involving carpal tunnel syndrome, will apportion away a large percentage of the permanent impairment due to the female gender, that females, especially postmenopausal females, very high percentage suffer from carpal tunnel syndrome. It seems to be a condition that has a predilection for the postmenopausal female. But to apportion a certain percentage of the permanent impairment to the gender risk factor of being female discriminates against women who have no choice and had no say in their becoming females in the first place. So to apportion away some of the permanent impairment rating to the female gender is discriminatory to the female gender, and it thereby unfairly reduces the benefits provided to injured workers who in this case are female. And so it was this lawsuit, this Page versus Parisotto lawsuit, which was filed in 2016, that exposed these several examples of gender discrimination in the workers' compensation system. And the lawsuit went on to conclude that because Because the Division of Industrial Relations and the Division of Workers' Compensation administer the state system of workers' compensation, that these branches of the government, these governmental agencies are responsible for the discrimination from happening in the first place, and they're responsible for addressing it, and they're responsible for rectifying what is described in this lawsuit as rampant discrimination, especially against women. And they went on in the lawsuit to cite some statistics that reveal that qualified medical evaluators are overwhelmingly male. And they cite some figures where in some specialties and in some locations throughout the state of California, you cannot find a female qualified medical evaluator. And because qualified medical evaluators are overwhelmingly male, these male evaluators may harbor stereotypes and implicit biases that ultimately result in discrimination in providing fair and accurate benefits to injured female injured workers. And you're going to see now directly from the language of the lawsuit wherein the Division of Workers' Compensation's new focus originated. They stated in the lawsuit that no portion of the system of medical evaluator training, certification, or continuing education addresses or is designed or is even designed to remediate gender discrimination. So notice here, this provides for the Division of Workers' Compensation several foci, several areas of focus, several areas upon which they can focus to address gender discrimination. They can address the training of qualified medical evaluators. They can address the certification of qualified medical evaluators. They can create continuing education for qualified medical evaluators in an ongoing effort to eliminate at least gender bias in the medical legal evaluation. Finally, they state in the lawsuit that neither the Department of Industrial Relations or the Division of Workers' Compensation have a policy or practice of sanctioning or disciplining medical evaluators or other employees who engage in unlawful sex discrimination in the determination of permanent disability benefits. Now, this is language directly from the lawsuit itself. And when I read these words, engage in unlawful sex discrimination, I would think that if qualified medical evaluators were found to repeatedly and repetitively and knowingly discriminate in their opinions and conclusions, that would qualify as engaging. It's my opinion, and I'm pretty sure it's the position of the Division of Workers' Compensation, that male evaluators who unknowingly or unwittingly apportion their permanent impairment ratings based on gender risk factors do that without malicious intent. They're not engaging consciously in unlawful sex discrimination. Rather, qualified medical evaluators are unknowingly are not realizing that what they are doing in providing apportionment to gender risk factors, they're unknowingly discriminating. So the Division of Workers' Compensation is planning on addressing this by copious continuing education, so that this concept rises to front and top of consciousness for qualified medical evaluators, and indeed for qualified medical evaluators who repetitively and stubbornly persist in discriminating against female gender. They are going to have a policy for sanctioning and disciplining those particular qualified medical evaluators. So with this as our background to the new QME regulations that we've been discussing, let's again review where and how the Division of Workers' Compensation is going to work us as qualified medical evaluators in an effort to address not only gender discrimination, but all of the other targets of discrimination as well. So the lawsuit stated that no portion of the Qualified Medical Evaluator's training, that's number 1, training, number 2, certification, number 3, continuing education, addresses gender discrimination. That's three areas that Qualified Medical Evaluators can receive continuing education or education. And then the DWC does not have a policy of being able to discipline Qualified Medical Evaluators who fail to be able to eliminate the gender discrimination bias in their opinions and conclusions. So the Division of Workers' Compensation, through their new proposed changes to the QME regulations and through at least one existing regulation, is targeting this very issue, is responding to this issue. And they're responding to this issue as follows. So with regards to training and certification, before Qualified Medical Evaluators can receive their initial appointment as a QME, CCR 11H talks about receiving at least 2 hours of anti-bias training before the Qualified Medical Evaluator can even sit to take the QME examination. Okay, so that's even before the QME credential is bestowed upon a prospective doctor. The doctor must go through anti-bias training. In the face-to-face evaluation, we've always had the disclosure requirements, which require you as the Qualified Medical Evaluator to sit knee to knee and talk with the examinee and let the examinee know that if they feel in any way that the doctor is discriminatory toward them, that they can leave. So this has been in existence and this is unchanged, whereas CCR 11H, this is new and it's designed to respond to the allegation in the lawsuit, which will address QME training and QME certification. Then, with regards to the Qualified Medical Evaluator's reports, the opinions and conclusions that the Qualified Medical Evaluator offers in their report, new CCR 35.5H requires the Qualified Medical Evaluator to provide a mandatory declaration at the end of their report, wherein the Qualified Medical Evaluator declares under penalty of perjury that they did not discriminate in any way against any party, including the examinee, the claims administrator, the applicant attorney, the defense attorney. Any party is not the subject of any discriminatory conduct or conclusion of the Qualified Medical Evaluator, and this is new. And then finally, on an ongoing basis, the Division of Workers' Compensation has proposed new CCR 55, which provides for anti-bias training, 2 hours of anti-bias training every 2 years as a mandatory requirement for reappointment for a new 2-year period for Qualified Medical Evaluators. And then for those Qualified Medical Evaluators who just don't get it, who just don't seem to be able to think clearly, who are not able to eliminate stereotypes and not able to eliminate implicit biases in their opinions and conclusions, the Division of Workers' Compensation has a remediation option to deny those Qualified Medical Evaluators reappointment as Qualified Medical Evaluators for a new 2-year term. So these are the new steps: CCR 11H, CCR 35.5H, and then 55, and then also 51.10. These are the new steps. Isn't that impressive? 4 new proposed changes to the QME regulations, specifically designed to respond to the allegations in the Page versus Perry Soto lawsuit. And in my opinion, this is a good thing. This is long overdue. And this is something that's going to result in an improvement in the system, because the intention is good. The intention is to provide fair opinions and conclusions for all persons, regardless of race, regardless of gender, regardless of country of national origin, regardless of religious affiliation. and regardless of sexual preference. And in my opinion, this is going to pass because it represents a positive change moving forward for the system. So doctors, isn't that fascinating? You know, the Page versus Parisotto lawsuit was filed in 2016. And here we are in 2021 with the Division of Workers' Compensation just now, proposing the new proposed changes to the QME regulations that are designed to address these allegations from over 5 years ago. Now, the Page versus Parisotto lawsuit was suppressed, and I'm not a lawyer and I can't testify or explain competently as to why that happened. But based upon my reading of the case and what my understanding of it is, and I could be completely wrong, my understanding is that this particular type of case could not be addressed in the court wherein the case was filed. It was filed in Superior Court, and the Superior Court ruled that they did not have the jurisdiction to rule on this matter, that this matter was uniquely and strictly under the purview of the Workers' Compensation Appeals Board. Now, I could be wrong, but that's simply my understanding of it. So the case failed to move forward. Now, until now, that is. Now, the women that filed the Page versus Parisotto lawsuit did not seek to harm the Division of Workers' Compensation or the Department of Industrial Relations. They weren't seeking monetary or punitive damages, except for fairness in their workers' compensation benefits, which they felt were unfairly reduced due to gender discrimination. They weren't seeking anything, but they were hoping that their efforts would result in some reform of the system such that moving forward, discrimination, especially gender discrimination, could be reduced and or eliminated, and that all forms of discrimination could be reduced and or eliminated such that injured workers could fairly receive the compensation that they are due, deserving, and that they qualify for without overlay and without issues, without discrimination related to various targets such as race, sex, gender, and all these other things. So in that sense, now that the Division of Workers' Compensation is moving forward with the new proposed changes, the Page versus Parisotto lawsuit has resulted in some positive changes to the system, which moving forward is going to result in more fairness for all persons injured in the course of their employment. So in my opinion, these are all good changes. These are fascinating changes. And these are changes that are going to require us as qualified medical evaluators to look deep inward inside our own implicit biases and stereotypes and attempt to rid those from our final opinions and conclusions such that injured workers receive treatment equally and fairly without discrimination. So I'm very much looking forward to the new era, and I'm very much looking forward to both the face-to-face evaluation and in writing my reports in the future under the new proposed changes in an effort to address my own biases and attempt to eliminate those from my medical reporting. So those are all good things. In our next session, I want to continue with some of the important changes in the QME regulations that are going to affect your day-to-day operations. In our next session, I want to talk to you about CCR 35.5 and how you can shift some of your time involved in your medical legal evaluation. I want to show you how to shift that time away from how you may have been spending too much time in the face-to-face evaluation and too much time on your physical examination. I want to show you how to shift that time more productively to create better, more useful reports for the parties who use your reports in the resolution of disputed issues. In a subsequent session, I want to talk to you about electronic submission of reports. This is something I'm very excited about because I see it as an efficiency and cost-saving measure, which is more important now than ever under the new medical legal fee schedule. So I'm very excited about the potential for electronic service of records even beyond the COVID emergency regulations, which are in place now, which do allow for electronic service of records. The new proposed changes are going to allow electronic service of records on into the future forever, and it's my opinion that this is the new profitability wave. And then finally, I want to share with you in our last session some of the areas where qualified medical evaluators can stumble, and where qualified medical evaluators can get themselves in trouble, which will result in disciplinary action for them. And I want to share with you these specific passages from CCR 51 in an effort to help you become a better qualified medical evaluator. Because CCR 51 and the denial of reappointment is only designed to eliminate the bad apples in our profession. It's my opinion that if you have some smell of a bad apple, you can be rehabilitated with a little bit of education and a little bit of awareness of the sensitive issues that the division is dealing with. If we can address those and handle those in you, you will in the end become a much better evaluator. And it's my opinion that that's the whole intention of the new proposed changes to the QME regulations. So for today, I want to thank you for taking the time to join me on today's discussion. I look forward to being with you on future discussions as well. And for now, this is Dr. Perry Carpenter. I'm wishing you best success in your career as a qualified medical evaluator.